judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. Welcome. We are very happy to have you here today. And we will hear argument first in United States versus Shields. And Mr. Page, whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Wesley Page, Federal Public Defender for the Southern District of West Virginia. On behalf of Mr. Shields, with me at counsel table is our appellate counsel, Jonathan Byrne. This case involves the district court's failure to address one of Shields' non-frivolous arguments for a downward variant sentence. That failure makes the sentence procedurally unreasonable, such that the judgment should be vacated and the case remanded for resentencing. Shields was charged.
So, Mr. Cage, can I just ask you what I think is the hardest question to me conceptually in this case by far? Let's posit that you're right, that at the time the district court absolutely should have addressed this argument. But if we vacate and remand, there's going to be a new sentencing proceeding at which the new amended guideline is going to apply, right?
That's not right, Your Honor.
Why?
Well, the guidelines, in effect, there would be an ex post facto issue.
How would it be an ex post facto issue to sentence your client under guidelines that would treat other people worse but not treat your client worse? The guideline that applies to your client would be exactly the same.
Well, now that I've reconsidered that, I think you are correct, Your Honor. So even if the guidelines are the same, we still have
No, his guideline is the same, but other people's guidelines are different in a way that eliminates this disparity you're talking about.
But at the time he was sentenced, and for several years under Campbell and light cases from other circuits, people in his same situation, convicted of felon in possession of a firearm with a single prior drug trafficking conviction, some of those folks were sentenced under a lower guideline range because Campbell said that West Virginia controlled substance offenses did not count as controlled substance offenses under the guidelines.
So he'd have a different argument. I guess my point is the precise argument he made wouldn't exist anymore because today offenders sentenced under those two states would get exactly the same guideline. No, but I guess he'd have the argument that there was some number of people who committed offenses at the same time I committed my offense, and those people, it would be, I guess, but at minimum you have to agree it'd be a different argument. That the argument he'd have to make at any resentencing proceeding would have to be different than the one he made at his initial sentencing proceeding.
I think it would be more nuanced. I would agree with that. I think the argument would be for a period of time, and that period of time would include the time in which Mr. Shields committed his offense and was sentenced originally. There were a number of folks who were sentenced under a disparate guideline. And that's the crux of the argument, is that unlike...
How do you respond to the government's argument that that's just sort of like intrinsic in the sentencing guidelines and the categorical approach and federalism? Like that's just a feature of having a guideline system and federalism and a categorical approach.
The categorical approach in the way the government made the argument was with regard to crimes of violence. And I think when we're parsing out statutes to determine whether they are a crime of violence using the categorical approach, you're at least trying to determine whether there is an element of force that is involved. There are certain enumerated offenses that would still qualify as crimes of violence. So I think under that...
I just mean as long as we have a categorical approach, there will always be situations where you could say, if I did the exact same thing in a different state, the exact same factual thing in a different state, my guidelines range would be different. That is intrinsic in having the categorical approach.
I have to concede that, Your Honor. But that does not negate the fact that this was a non-frivolous argument for a downward variance, because the fact of the matter is, if Shields had committed his prior offense in the state of West Virginia and been convicted under West Virginia's statute, Campbell would have applied, his base offense level would have been 14, and his guidelines would have been different. If the government wanted to make an argument that shouldn't matter, or that we should vary upwards in cases where Campbell did apply, they could have done that. They didn't. If Judge Goodwin wants to make that finding that this argument is not going to carry the day, he could have done that. He didn't. He may do that on remand. But the fact that that's a plausible or potential outcome of this case does not negate the fact that this was a non-frivolous argument and that he didn't fail to address it.
Counsel, what if I think that the argument was not frivolous, but it was relatively weak, that what the district court was really worried about and troubled by was your client's criminal history. And that, relatively speaking, it was most unlikely that this I'm assuming now, non-frivolous argument was really going to move the needle. Is that a harmless error?
It is not harmless error, Your Honor, and I would push back on the thought that this is a relatively weak argument.
Yeah, but just assume for a minute that I think it is.
Okay, it's still not harmless error because you can't assume that Judge Goodwin would have done the same thing had he considered this argument.
And how do I square that? Let me just say that I'm sympathetic to I don't really understand how this kind of error can be harmless, but yet this court has said it can be. So explain to me, I guess what I need, for you to explain to me why this isn't harmless, I need you to explain to me in your view, what is harmless? Because we have said there can be harmless error.
There can, and I read those cases, and the cases are kind of all over the map in this area.
I don't disagree.
To me, in some ways, frivolous and harmless error are subsumed. And in this case,
All right, that seems like it would be a very logical way to think about the world, that there is sort of a materiality requirement built into the rule. And so, of course, it can never be harmless. But again, we've said it can be harmless, and I am really struggling with trying to figure out how that operates.
I'm trying to think back as to the cases in which harmless error was found. I think there were significant aggravating factors in those cases that the district court did discuss thoroughly and did rely on.
But that's this case. The district court discussed pretty thoroughly its concern about your client's criminal history.
But at the end of the day, the district court tied the sentence to the bottom of the guidelines. He said, I wouldn't be giving you a bottom of guideline sentence if, and to me, that indicates that Judge Goodwin felt some sort of tie to what the guideline range was, such that if Shields would have had a lower guideline range, he very well may have sentenced.
I agree with that, but I think we're talking about harmless error at two different stages. I think what we have suggested in our cases is that there can be cases where it's not that if the district court had been moved by this kind of Campbell argument and the guidelines range and had granted a downward variance, I think our case law would say, well, then that's not a harmless error because he was tying this to the guideline range. But I think the argument for why it is harmless is that we can tell, based on what he said and his profound concern about criminal history, that this argument was not going to persuade him to grant a downward variance.
I think under this court's jurisprudence on this particular topic, that's reading too much into what Judge Goodwin said. And maybe he did consider that, and maybe he would give the same sentence on remand, but you can't tell that from the sentencing transcript.
Can I ask you, and I will let this go a little bit, it seems to me that in thinking about harmless error and how it would apply in this context, it would be helpful to know what is the point of the rule in the first place. Why do we require district courts to address non-frivolous arguments for lower sentences? And it could be just to make sure that the court has actually considered the argument. And so if the context makes clear it's been considered, we could say that's harmless error. But it could have to do with the explanation itself, either because the defendant is entitled to an explanation or the explanation is helpful for us on appellate review, or because we think that maybe the fact of articulating your explanation might make you reconsider. Do you have a view on what is the point of this rule in the first place?
I think you articulated it well, Your Honor. I mean,
Which one of those?
Yeah.
well, I mean, I think it serves multiple purposes. This all flows from Gall. And it helps with appellate review. It gives you guys a basis to understand what the district court was thinking when it imposed sentence. And I think you raise a very good point that it tells the defendant what the court was thinking. I listened to an argument from earlier this week on this exact same topic involving another panel, and defense counsel there made a very...
Wait, this exact same argument? Like intervening change of the guy?
Well, not intervening change.
Failure to explain
Failure
outcome.
to explain. And defense counsel said, if I have to turn to my client and he says, why did the judge sentence me there, and I have to be the one to explain it, there's been a failure.
Well, let me ask you a hypo that has occurred to me that sort of gets at what Judge Harris is saying. Say that this is an actively engaged judge at sentencing, and they have backs and forth, and the defense makes proffers, and the government makes proffers, and the court's asking questions. It's very clear the court's sort of engaged with the process. And then at the end of the hearing, the court says, look, Mr. Page, I've listened to everything you've said. I've listened to everything your client said. I understand your arguments. But at the end of the day, I just can't get past X, Y, and Z. And so the sentence is 80 months. Is that enough in your view?
That's a better case. We don't have that here.
Sure, I totally understand you don't have that here. But, so in other words, in pronouncing sentence, I don't expressly address your argument, but I say, the reason I'm rejecting all of your arguments is X, Y, and Z.
That very well may be.
Or I think all your arguments are outweighed by X, Y, and Z.
That gives context. That gives context to maybe suggest that that argument was considered. Again, we don't have that here. Judge Goodwin never mentioned unwarranted sentencing disparities. Judge Goodwin never said, I read everything. He was very focused on the guideline issue, and once that was resolved, he spread on the record the guideline calculation and proceeded to pronounce sentence. We made the variance argument. That was the thrust of our sentencing argument. We made it in our objections to the pre-sentence report, or the response to the government's objection. We made it in our sentencing memorandum and again at sentencing. And for him to not address that at all indicates to me that it wasn't on his mind. There are other judges.
He was, counsel, he was that was loud, sorry.
Oh, my God.
I'm a little nervous. I'm not going to speak.
I passed this time.
I wanted to say that he was aware of our decision in Campbell, was he not?
He was, and he discussed that thoroughly. But he discussed it in the context of resolving the guideline objection without mentioning its disparate impact on defendants who had prior drug trafficking convictions from other jurisdictions. Some of the judges in our district will ask defense counsel at the conclusion of a sentencing hearing, have I addressed all of your arguments for a variant sentence? I think that's a good practice because I think an answer, yes, Your Honor, you have, would waive any appellate issue we might have on this theory. But again, Judge Goodwin didn't do that. So at the end of the day, it's clear that he didn't address it.
And how much explanation, I realize we may not need to get there, but how much explanation do you think you would need? Could the judge have just said, yeah, what you're raising is just kind of what the guidelines do, so no. You're objecting to the existence of the guidelines and the existence of the categorical approach.
If he would give me a chance to push back on that position, I think that would
But then he says, I'm just not persuaded, because I think what you're fundamentally doing is taking issue with the very way the categorical approach
Then at
works.
the end of the day, if that would give context that he had considered it, and I don't think we would be here. Again, here, he never mentioned it. There's no dispute as to that. You can't glean from the context of this that he considered it. That results in procedural unreasonableness, and that requires vacation and remand.
Can I just, I'm sorry, and I know you're out of time, and I will try to be quick. You've just said considered a couple of times. So is that what we're looking for? So if we think the judge considered the argument, is there a violation if he does not explain why he rejected the argument? If we can be confident, I mean, he says, I've considered your arguments.
And I'm trying to remember what the quote from the case law requires. I think considered and addressed are kind of used
They are used,
interchangeably.
yes, but that seems problematic because they're different things.
If he considered it and found it to be, and from the context of the proceeding, found it to be unavailing, then I think that's sufficient. Again, that's not what we have here. So if there are no further questions, thank you.
Thank you.
Morning, Your Honors. May it please the Court, my name is J.C. McCallum. I'm an Assistant United States Attorney with the Southern District of West Virginia. Here, the District Court did not commit procedural error as it made sufficient findings related to the sentence imposed when it accurately calculated the sentencing guidelines. The
Is-
court.
Is that it? So long as the guidelines are accurately calculated, there can be no procedural error through failure to explain?
No, Your Honor, I would not
Okay.
say that's it, but I would say that in this case, the heart of the issue, the heart of the defendant's request for downward variance was criminal history. That is the basis of their request for the variance. Criminal history was considered, again, when the court carefully considered or calculated the guidelines and addressed criminal history as a whole, didn't look at the single conviction of the defendant. As the defendant has conceded in their reply brief, the operation of the guidelines themselves address disparate treatments of defendants. So that is,
No, the defendant is saying, I think, the operation of the guidelines themselves, this is the rare case where it's the guidelines operate to cause the disparity. So I don't see how saying, well, he properly calculated the guidelines, it doesn't address the argument, it creates the argument.
the guidelines did not create a disparity for this defendant. And the guidelines are not
Well, what-
created to address disparities between defendants from state to state.
Yeah, but I just don't understand how calculating the guidelines is sufficient to address an argument if the argument is, in my case, the guidelines operate to create this weird disparity because you have Campbell for West Virginia and people who are sentenced with a West Virginia conviction are getting a different result than I am. How does saying, well, I calculated the guidelines address that?
And Your Honor, I would push back and say that the guidelines themselves are in place to address unwarranted disparities.
Right, that's an argument why the district court could and perhaps should reject his argument, not that the district court did address his argument.
And Your Honor, again, I would say that his argument at the heart of that is criminal history. So we can't take out criminal history, which we know the district court very thoroughly addressed, and say that his request for a downward variance was not
That
addressed.
doesn't make any sense. Criminal history for some defendants is a sprawling category. And you could say, I have a problem with point A on criminal history, and just because the district court addressed criminal history generally or addressed D, E, and F parts of criminal history doesn't mean they've addressed my argument about A.
I mean, sorry.
Am I right about it? It can't just be that simply because the district court said some things about criminal history and just because the defendant's argument is in some ways about criminal history, that means it's necessarily sufficient. That seems way overbroad.
If anything, doesn't it make it worse? If you have an argument, say your argument is my criminal history overrepresents the culpability of what I did and the violence of what I did. If the district court then says, well, based on your criminal history, I'm giving you this sentence and never addresses your argument, that makes it worse.
In that scenario, yes, Your Honor, the court should address that. But again, that's not the case here because the guidelines as applied worked correctly for Mr. Shields. He creates a hypothetical defendant. If someone in West Virginia committed a controlled substance offense, which he did not, that was not his underlying conviction. If that person was sentenced as he were, they would have a lower base offense level.
Right, they would have committed engaged in the exact same conduct, exact same culpability, but one of them is going to get a lower sentence now because of this weird Campbell quirk.
Because of the weird Campbell quirk, yes, but again, that did not apply to this defendant, and again, the guidelines are not there to address hypothetical defendants or state-to-state variances. This is a nationwide thing that the guidelines are set to make sure that there aren't disparities.
So just doctrinally, you are saying this was a frivolous argument and the judge didn't have to address it?
I believe the judge made sufficient findings, but if the court believes it did not, the argument itself is frivolous. I would say that it's not just a relatively weak argument. I would say it's frivolous because this argument can't prevail. Again, Campbell didn't apply to Shields. The guidelines are not made to address individual or defendant-to-defendant differences in sentencings. So making that argument.
Wait. Wasn't literally one of the point of the sentencing guidelines to address defendant-to-defendant disparities? Like, wasn't that literally one of the main points of the sentencing guidelines?
Generally, but not a hypothetical defendant in a different state, which happens to be in a different
Well,
circuit.
why does it have to be a hypothetical defendant? I mean, I presume with a little bit of effort, we could find an actual defendant, someone who was actually convicted of one of these other crimes in a different state.
Maybe
It's-
Mr. Campbell.
I mean, you're not saying that the problem, the only reason his argument fails is that he didn't, find an actual person for whom this was true to.
No, Your Honor, I'm not.
Okay.
I'm saying his argument fails because the operation of the guidelines don't address what they want.
So, I mean, I guess I'm coming back to where Judge Heitens is. Everything you are saying sounds to me like a thing the district court could have said to explain why he was not going to grant a downward variance based on this argument. But I do have a real concern. As I read the transcript, it does sort of look to me like the district court not only didn't address the sort of separate equitable argument arising out of Campbell, but also didn't consider it and maybe didn't know that he was supposed to, because it was not that long before this sentencing that we first decided in Torres-Reyes, made very clear in a case like this, you've got a legal argument about why the guidelines should be lower, and then an equitable argument about, even if you're wrong about the legal argument, the judge to take that into consideration. And that was the first time we ever said, look, you've got to address both of those. Those are two distinct arguments. And I'm just not confident in reading this transcript that the district court addressed the equitable version of the argument.
And Judge, again.
I mean, I know he didn't address it, that he considered it. I don't have confidence that it was even considered.
I would say it was considered, again.
And what makes you think that?
Again, at the heart of the downward variance argument was criminal history. I don't think anyone
So
would
you
disagree.
think when he said criminal history, he meant that's your equitable argument about Campbell?
Correct, because what
Okay.
we're looking at, they're saying, hey, criminal history in West Virginia, again, this is criminal history in Ohio. These two, that is the heart of it. And I believe if you look at it that way, then he certainly addressed it. The criminal history was the crux of the decision, the reason why he gave an in-guideline sentence.
What is your best authority, like case or whatever, for the proposition that this argument is frivolous? A case of this court, a case of the Supreme Court, a case of any Article III court?
I would say, again, the argument is frivolous. I don't have a specific case to give to you, Your Honor.
Okay, and how do I square that the argument that it's frivolous, I was looking this up, with 3553A6, which says the need to avoid unwarranted sentencing disparities among defendants with similar records who have been found guilty of similar conduct? Why isn't his argument quite comfortably within 3553A6?
And Your Honor.
It doesn't say similar conduct in West Virginia or similar conduct within the state. It says defendants with similar records and similar conduct.
Correct, and there's a reason it's not similar conduct in West Virginia. This is, again, to look at similar conduct nationwide. That is the purpose of the guidelines.
And his argument was, if you look at defendants who committed similar conduct in other states, they would get lower guidelines ranges than me.
And Your Honor, if I could quote this court in, I believe, Suero, as I did in my brief. This court said, district court is not required at sentencing to examine the records of various other people. Suero identified who had been convicted of similar or more serious crimes. The requirement of procedural reasonableness does not obligate a trial court to engage in case-by-case comparisons.
That was a
This-
different context. What's distinct about the argument being made here is that here the argument is the guidelines cause the disparity. In Suero, it was different. It was just like you've done similar things and the guidelines don't sort of capture those differences. But here it is actually the operation of the guidelines and the categorical approach that is causing the problem. So I just keep coming back to, like, I don't think we can point to, well, the guidelines take care of the disparities themselves in this case.
And Your Honor, I would argue that there was no disparity. I understand what they argued, but if you take an identical defendant to Shields, someone who had an underlying state of Ohio drug conviction, he was sentenced and the guidelines were exactly like that defendant would be. And
But you're just, so your whole argument hinges on sort of who we pick as our point of comparison, because his argument is, no, I want a defendant who did the exact same thing as me, sold drugs in the exact same way, but because he happened to be sentenced in West Virginia and not Ohio, he is now getting a dramatically lower federal sentence on the crime we both committed.
I'm saying that that's what goes to making the argument frivolous. I'm not suggesting that's the analysis that we should take, but it goes to why I believe it's frivolous. Even if this court believes that there was procedural error, I would submit that that error was harmless. It is patently clear from the transcript, patently clear from the colloquy with the court. If this is sent down for resentencing, there will not be a different sentence. To Judge Hyten's point, Mr. Shields would have to make an entirely different argument than the one he made at the original sentence. I don't think anything would lend itself to there not being a different outcome than that.
So can I ask you that? So that's an argument that it was harmful at the time, but has become harmless because of intervening events mean that any resentencing would be governed by a different regime. I have never encountered a case that raises that question, and nor have I been able to find a case that addresses that question of like, at what point is harmlessness assessed? Like, is it assessed at the time, or have you found any case that bears on the, do we consider whether it was harmless at the time, or are we allowed to consider whether it would be harmless today if the same thing happened? I will say I've not been able to find a case. I'm asking if you've been able to find a case.
Not aware of a case, Your Honor, no, but I think it does go to the analysis of if it is sent down to the district court for resentencing, there's an entirely different argument that needs to be made. But again, we don't have to speculate as to would, again, in the event that you believe there was procedural error, if the court would have, and I believe the court did consider the issue, but had it been more thoroughly considered, would there be a different sentence? And I would submit the answer is no. And again, that is clear based on Judge Goodwin's sentencing where he says, he all but says, I would sentence you higher, but for the fact that you are serving a 29 to 34 and a half year sentence in Ohio, that this is going to run consecutive to. So he's suggesting because of your abhorrent criminal history, I would have gone higher, but you're already receiving a decades-long sentence in Ohio.
So let me ask you another question that seems to bear on the harmlessness question. Do you think that if the district court had accepted this argument and given him a lower sentence based on this argument, that his sentence would have been substantively unreasonable? Hypothetically, so the district court addresses the argument, the district court says, you know, actually that's kind of an interesting point and that is kind of troubling, so I'm going to lower the sentence I would have otherwise given by a month or 2 months or 3 months. Do you think it would have been substantively unreasonable for the district court to have done that?
No, Your Honor, but nothing based on the transcript would indicate that's what the district
No, it's a
court would
hypo.
do.
But I mean, one of the ways to discover if not addressing the argument is harmless would be that if the district court had addressed the argument, it would have been legal error to have accepted it. That it would be a pretty good argument that something's harmless.
I don't believe it would be legal error to accept it. I just believe that it was addressed.
So from the way you're talking about harmlessness, it sounds like, and some of our cases talk about it this way, the question is, would the sentence be different? But we also say in cases like Ross that part of the point of this explanation requirement is that the defendant is entitled to hear from the judge why the argument hasn't been accepted. And so if that's part of the purpose, does it follow that, well, the sentence might be the same on remand, but at least this time the defendant will get what he's entitled to, which is an explanation from the judge as to why the argument was found lacking?
And that is important, Your Honor, and I believe this is very distinguishable from Ross. In Ross, we had a downward variance request based on a mental health issue, and that is a very individual characteristic of that defendant that would require treatment from the district court. Here, what we have is a general criminal history characteristic that, again, was very thoroughly addressed by the district court.
That seems like you're just saying there was no error. If you could assume for a minute that there was an error, even if I thought, I'm pretty sure the district court is not going to change the sentence on remand, I might still, what do I do with this other purpose of the requirement, which is, well, he might not change it, but you will at least get the part of the rule that is about having the judge himself explain to the defendant why the argument was not compelling.
And Your Honor, if I may address your question, I understand I'm out of time. I would say that, again, that rule is important. The individual characteristics should be addressed by the court, but I would submit that in this case, what they're arguing is not an individual characteristic. It is a more general criminal history to hypothetical defendants, so it did not require explicit treatment by the district court.
Okay. Judge Berner, do you have questions?
Yes, I have a question taking you back to the amendment to the sentencing guidelines. Your colleague suggested that Judge Goodwin, if the case were remanded, would not be able to consider the amendment. I'm wondering if you have a view on that question.
I think you could consider it, Your Honor, in so far as it indicates policy reasons as why the amendment took place, but as has been thoroughly discussed, the amendment would not apply to him because he was a base offense level 20 all along, so the amendment didn't affect him. It wouldn't be an ex post facto issue because it didn't change anything. Obviously, he's not entitled to a lesser treatment because, again, it never applied. So it could be considered to examine policy considerations, which I think would just further support the sentence that was given by the district court.
But it wouldn't apply to him.
Correct. It would not apply to Mr. Shields.
Thank you.
All right, well, thank you very much. We appreciate it. Some rebuttal time?
Thank you. Judge Heitens, I first want to address, come back to your discussion about this is kind of what the guidelines do and these kind of disparities are what we should live within the guideline system. The guidelines are but one of several factors that district courts are required to consider when doing an individualized sentence. And I would push back on that by saying avoiding unwarranted sentencing disparities is another one of those factors.
Right.
And when the guidelines operate to create an unwarranted sentencing disparity, 3553A6 should operate to cabin the operation of the guidelines. And that's what we're asking to happen here.
Yeah, I just feel like, right, I mean, maybe before Booker, that would have been an argument. Like, you can't depart from mandatory guidelines based on a fundamental disagreement with how the guidelines work. But we're in a post-Kimbrough world now. We can do all kinds of stuff.
We are, and I think if I were ever to be a district judge and was confronted with a close call on a guideline issue, I would try to go to what are the facts and the law that supports all that. Here's what actually happened. And if I'm going to parse that out one way and the guidelines are base offense level 20, I parse it out the other way, base offense level 14. I would impose sentence almost without regard for either way. And that's not what Judge Goodwin did here. The fact of the matter is, for several years, post-Campbell in West Virginia, and the same thing happened across the country. This issue was percolating in other circuits before it made its way here. But for several years in the Southern District of West Virginia, folks who pled guilty to being a felon in possession of a firearm with a prior felony drug conviction in West Virginia or any one of the similar states were sentenced under a lower guideline range than what Shields was. To me, that is an unwarranted sentencing disparity. And nothing from the sentencing hearing made it patently obvious that Judge Goodwin would have imposed the same sentence, notwithstanding our argument for a disparity. And Judge Harris, that's, to my understanding, that's what it comes back to for harmless error. It was patently obvious from the transcript that the sentence would have been the same. Nothing in the transcript, in my view, indicates that it would have been the same. Yes, there are some aggravating circumstances with regard to Shields' criminal history, but Judge Goodwin doesn't say he would have imposed the same sentence regardless. As I mentioned previously, it was a bottom of guideline sentence, indicating to me that he felt constrained to some extent by what that guideline range was. If this goes back for resentencing, I want to make the record clear from our perspective, there is no ex post facto issue because the guidelines would be the same for Mr. Shields, regardless of which guideline manual is used. I think there's some fundamental unfairness to send it back and say.
So if we're literally talking about the question of if I'm the district court judge and I'm resentencing and I have my books on the bench, which book do I pick up in this hypothetical world where we're using the actual guidelines manual?
It would be the current
The
guidelines.
the current one as of resentencing.
As of resentencing, yes, Your Honor. But that does not eliminate our non-frivolous argument for a variance based on the sentencing landscape at the time Shields was originally resentenced. And I would argue that it is fundamentally unfair to change that. So for those reasons, we would ask the court to vacate and remand for resentencing. Thank you.
Thank you very much. All right, we will come down and greet counsel and then move on to our next case. Okay, we will hear argument now in, sorry, in Modern Perfection versus Bank of America. And is it Mr. Zapirian?
Yes, good morning, Your Honor.
Whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Nathan Zapirian. I have with me today Kelly Tucker and Lena Herbert. We represent the appellants in this matter. We're asking your honors to overrule or reverse the motion to compel arbitration granted by the district court in this case, and further to find that that motion to compel arbitration should be denied and that the case here should be subject to the terms of the promissory note and not the deposit agreement at issue. 4 years ago, in March of 2020, we were in a different world. It was the beginning of a pandemic. The government passed the CARES Act, and the Paycheck Protection Program, the PPP, was part of that act. The PPP was intended to provide relief to small businesses and to incentivize them to keep paying their workers by offering forgivable loans for payroll costs, among other things. Private lenders, including the Bank of America, were offered commissions for processing and facilitating those PPP loans. In March of 2020, Bank of America started soliciting its small business clients, including the appellants, to apply for PPP loans through the Bank of America. Thinking that they were being thrown a life preserver by Bank of America and the government, appellants applied for PPP loans ranging from tens of thousands of dollars to, in some instances, more than $100,000 to use for purposes that they believe, based on what they've been told by the Bank of America, made the loans forgivable. In 2022, however, when appellants sought forgiveness for the loans, they discovered that the Bank of America had not thrown them a life preserver, but instead had handed them an anchor. That because the loans that they received were used in accordance with representations made by Bank of America to pay 1099 workers instead of W-2 workers, those loans were not forgivable. This happened despite the fact that Bank of America had indicated to appellants that they needed to supply information related to 1099 workers, and further, that they would verify the loans before they were submitted to the government.
Okay, I wonder if we can just, so that's the claim, and I think
Yes.
we understand it,
Yeah.
and the question is whether that claim will be arbitrated or not, right?
Yes. So certainly we can jump ahead, Your Honor.
I think we probably should.
There's two agreements at issue here. the deposit agreement and the promissory note. They're the focus of the argument here. Both of those agreements were drafted exclusively by the Bank of America. The appellants entered into the promissory notes in April 2020 and May 2020 in direct connection with their receipt of PPP loans. In contrast, the appellants entered into the deposit agreements between 2006 and 2022, not contemporaneously with receiving the PPP loans, and in fact, in connection with establishing a distinct relationship, a banking relationship.
So that
with
sounds
Bank
like
of
an
America.
argument. I just want to make sure I understand where we are in your argument. That sounds like an argument that these PPP-related claims are not within the scope of the arbitration clause in the first agreement, right?
Well, so the scope versus existence question is a relevant question, obviously, Your Honor. What we've argued is that the deposit agreement has no relationship to the PPP loans at all. And if you look at the decision.
Right, which
in-
would be a reason why your PPP claims do not arise under the
Exactly.
deposit agreement for purposes of applying that arbitration clause.
Exactly.
Okay.
So-
Can I ask you, your 28J letter says that you're making an argument under Coinbase. What is your argument under Coinbase?
So under Coinbase, Your Honor, essentially, it mandates reversal of the district court's decision in circumstances such as this. In Coinbase, as here, there was an agreement with a delegation clause and a subsequent agreement that had a jurisdiction and venue clause that sent the disputes to the courts. Coinbase said that in such a situation, it is up to the court and not an arbitrator to decide the threshold issue of arbitrability. So the fact that the district court opted to send that issue to an arbitrator is directly contrary to the finding in Coinbase.
You think that the holding of Coinbase is that whenever you have these two different agreements, arbitrability is for the court?
Yes, Your Honor.
See, I read Coinbase differently. I think, you know how Coinbase has those 4 steps? Or four orders of questions. I think all Coinbase is saying is that if you have two agreements that in some way point to different answers to the question of who will decide arbitrability, a court has to decide which of those agreements governs as to whether arbitrability will be decided by the arbitrator or by the court. Does that sound?
Yeah, and
It's a
I'm
lot.
sorry if I misinterpreted your previous question. I think that is exactly the holding.
Okay, so
And-
I think for me, it is really important to know what Coinbase argument you think you're articulating today and whether you think you also articulated that argument before today.
Okay, well, Coinbase obviously came out after the briefing in our case.
I mean, that is true, but your colleague's responsive brief sort of flagged Coinbase, said Coinbase is in front of the Supreme Court, but the plaintiffs have not exhausted that. They've never mentioned it. And it's not like in your reply brief, you said, oh no, we're making a Coinbase argument and we have exhausted it.
Well, we didn't specifically reference Coinbase in the briefings, Your Honor, but we have throughout our briefing challenged the validity of the delegation clause in the deposit agreement as it pertains to the PPP loans and the claims related to those loans. It's a little bit of losing the forest for the trees if you don't recognize the fact that throughout our briefing, we've challenged the validity of the deposit agreement. And certainly.
Okay, so let's put this in the context of the 4 questions Coinbase says. Coinbase says there's like 4 levels of questions. Question 1 is the merits of your dispute with Bank of America. And that's the very thing we're trying to decide whether to arbitrate. Coinbase says question 2 is there an agreement to arbitrate? Like, just look at it in isolation that covers this claim. Question 3 is, does that agreement say that the arbitrator decides arbitrability? As I read the district court's opinion, it says under question 2, there is an agreement, it's the deposit agreement. Does it delegate arbitrability? It does delegate arbitrability. That's what I read the district court to say. But then Coinbase says there can be, in cases where there are two contracts that might govern the arbitrability question, there can be a question of which contract governs the arbitrability question, what Coinbase calls category 4 or question 4. The concern I have is that a lot of your arguments sound like category 2 arguments, and those arguments to me seem, I'll just say it, pretty clearly sent to the district court pretty clearly determined category 2 arguments go to the arbitrator. But it is also true that one thing you say over and over in your brief is the district court was wrong, the relevant agreement isn't the deposit agreement, it's the promissory note. And that starts to sound more like a Coinbase argument to me. So, but I think for purposes of making the argument I think you are allowed to make under Coinbase, we have to just ignore the deposit agreement and assume that the district court was right in saying that that says arbitrability. And now the question is, does the deposit agreement in the language of Coinbase supersede that? Does that, so could you focus sort of on that and where you preserve the argument not that the deposit agreements don't call for arbitrability, but that the district court was wrong in viewing that as the relevant agreement for purposes of answering this question?
So I agree with your analysis, Your Honor, that we're really looking at the 4th section in Coinbase,
Okay.
at least initially. I think once we get past that, you look more at which of the two agreements actually should control here.
Oh, I think that is the Coinbase question. Which of the two agreements should control here?
Well, in terms of arbitrability, yes. So throughout our briefing, we challenged the validity of the deposit agreement.
That is what I don't think you can do. You can't challenge, I think you cannot challenge the validity of the deposit agreements. You have to say, let's assume they're valid, it's just the deposit agreements don't govern arbitrability here, it's the promissory note. Where did you say that?
I can't point specifically to a place where we say that in our briefing, Your Honor. So what we have said is not that the deposit agreement is invalid
Okay.
overall. What we've said is that it doesn't apply to the PPP loan claims that are at issue here.
That's a
And-
level 2 argument. That's an argument that these claims are not within the scope of your deposit agreement
Even
arbitration
absent
clause.
the promissory note.
Right. Right, so let me ask the question that way. Say there were no promissory note. It was just, you're looking at this deposit agreement, and you just don't think that something you did over here involving loans under the PPP program arises under or is related to your deposit relationship with BOA. I mean, would your argument be much different? The argument you made in your briefs to us, made before the district court, would that argument be any different if there were not promissory notes? I mean, wouldn't you be saying basically the same thing?
Yeah, I'm not sure it would be different, Your Honor. There still needs to be a significant relationship between the deposit agreement and the claims at issue here in order for the deposit agreement to be validly controlling. The distinction, though, Your Honor, is in looking at which party decides arbitrability. I mean, Coinbase looks at the exact situation that's present here and finds that a court has to make that decision.
But Coinbase, I agree. In some ways, the two agreements in Coinbase and the two agreements in this case look quite a bit alike. There's a lot of similarity. I agree. But what Coinbase doesn't say is that the court gets to decide whether Agreement 1 would call for arbitration absent Agreement 2. What Coinbase says is a court gets to decide whether Agreement 1 or Agreement 2 controls the question of arbitrability. And it seems to me that your arguments, at least in the main, I'm not sure exclusively, but in the main, are about question 1, which is not the thing that Coinbase says we can do.
Your Honor, I think that the entirety of our argument has always been that the promissory note should control here. That's correct. And whether that is...
Because it doesn't provide for arbitration, because it mentions courts, because it has a venue clause, because it has a merger clause. For all those reasons, you think that's the contract that controls arbitration here?
Right. But in order to get there, you first have to decide the question of who decides arbitrability. And the district court decided pre-Coinbase that the party that should decide arbitrability was an arbitrator.
Let me try to ask the question this way. Assume hypothetically, I think everything the district court said was right. The district court said, everybody agrees there is an agreement to arbitrate in this case. Everybody agrees that. The agreement is in the deposit agreement. And under that arbitration agreement, the parties have agreed to arbitrate arbitrability. Your argument that these claims do not arise under and are not related to in any meaningful way the deposit agreement, that outside the scope of the deposit agreement, that will be decided by the arbitrator. Assume for a minute, I think all of that is correct in as far as it goes. Do you think there is still a Coinbase argument if everything the district court said was right?
Yes, Your Honor, because I think that Coinbase clarified the paradigm that we have to look at these cases through when you have two separate agreements, one of which does have a delegation clause and one of which has a venue selection clause, and there's a conflict between the two.
Okay, so assuming that everything the district court said was right, you would go to the district court and say, everything you said was right, but, and then what would your argument look like then?
The argument would be that since the decision, Coinbase has clarified the relevant law,
Yeah, but
And now you
the
should do what?
substance, yes, what is the substance of your
and
argument?
now, the initial instance should be that the court and not an arbitrator should decide the arbitrability of these claims.
Well, no,
That's not
no,
what
no,
Coinbase
not
says.
Coinbase doesn't say that, because let's say the district court does the Coinbase analysis, the what contract controls here question, and the district court concludes that it is contract one, and if, again, I know you don't agree with this, but positing as Judge Harris did, that everything the district court said is right, it seems to me that if the district court concludes that contract one controls arbitrability, then the district court just enters the exact same order, and the arbitrator decides arbitrability.
If it is possible that the district court could reach that conclusion, Your Honor, and one of the errors that we assigned to the district court is that when it looked at those two agreements, it barely looked at the promissory notes at all, and instead, despite the fact that the claims are related to the promissory note, looked to the deposit agreement and the delegation clause therein for instruction, rather than looking at the agreement that actually pertains to the claims at issue.
Can you speak about the delegation clause specifically, and are you arguing that the delegation clause is valid?
So we are not, we're arguing that the delegation clause is invalid, Your Honor, because it's part of our challenge to the overall deposit agreement. We've argued
So you don't
throughout-
have a separate argument as to the validity or invalidity of the delegation clause?
Well, Your Honor, we do think that to the extent that you get to whether it clearly and unmistakably sends the issue to an arbitrator, that the language used by Bank of America was not consistent with the exacting standards set forth in Peabody.
But haven't, like, all kinds of cases said that this exact language is sufficient to delegate arbitrability?
Not this exact, well, some cases have said that, have looked at this exact language, but
And
most of the
They've all
cases,
said this exact language is enough to delegate arbitrability.
I don't know that it's the exact language, Your Honor. I
Okay,
think,
how about we flip
and
this
it's certain-
around? Can you identify any case that says language like this is not sufficient to delegate arbitrability?
again, not this exact language. However, there is an important distinction between those cases and this case. And that distinction is, in those cases, you're talking about one agreement at issue. And here, there are two agreements at issue, and that changes the entire paradigm as Coinbase held.
Judge Berner, do you have more questions?
I wanted to ask about the issue of staying versus dismissing the case. Did you request a stay before the district court?
We did not, Your Honor. So I think that the Fourth Circuit law and the recent Supreme Court case and the Smith versus Parisi case does highlight the fact that a stay should be mandatory, but I do recognize that the Smith case talks specifically about there being a request to stay. I think that the logic and reasoning that is behind the FAA making the stay mandatory is still in effect here, but in response to your Honor's question, no, we did not request a stay.
Okay, well, thank you very much. Hear now from Mr. Smallwood.
Good morning, Your Honors. Jesse Smallwood from Williams & Connolly on behalf of Appellee Bank of America. May it please the Court. Your Honors, the District Court's decision to grant B of A's motion to compel arbitration was a straightforward application of settled law and undisputed facts to the arguments advanced by appellants below. The District Court correctly concluded that the parties had executed an arbitration provision that contained a clause that clearly and unmistakably delegated all questions of arbitrability to the arbitrator. It also correctly concluded that all the arguments advanced by appellants below were ones for the arbitrator and not the court to decide because they went to the issue of arbitrability and not to the issue of contract formation. Appellant's argument on appeal...
Can I ask you just a question that's rattling around in my brain about the whole why are we here question?
Sure.
Why doesn't this promissory note have an arbitration clause?
It's a good question, Your Honor. I think that because it doesn't need to have one, right? Because...
Okay, that's clearly not true. It clearly would be much better for Bank of America.
It
if this
would have been better,
promissory
like,
note had an arbitration
look,
clause.
I think looking back in retrospect, if they had to do it all over
I
again,
guess
they
my
would put an
working
arbitration
assumption has just
provision in.
been- My working assumption is every time I sign anything with a bank ever, I'm consenting to an arbitration clause. I was just surprised that this one, like, I guess, so let me ask, other than facetiously, I've been wondering this whole case, but, like, is there a legal, were you legally prohibited from it? Like, was there something in the
Not that I'm aware of, Your Honor.
CARES Act that forbid, okay.
No. I mean, I think, to be all frank and honest with you, I have not spoken to the person who drafted the agreement, so I don't know exactly what was in their head. But this was also in the middle of the pandemic. They also, and I think that this is very important to kind of understand as a backdrop, the Bank of America required that anybody who applied for a PPP loan with Bank of America had to have a depository relationship with Bank of America. And in fact, in the promissory note, as provision 1 of the promissory note, it required that the PPP recipients maintain that deposit relationship for the life of the PPP loan. In fact, it would be a breach of the agreement not to, so that BofA had the right to withdraw the money from the deposit agreement. There was a lot of reasons why Bank of America required a baseline depository relationship with Bank of
And I
America.
guess one hypothesis is if you have a depository agreement, you've already agreed to arbitrate if we
Correct.
ever get into a disagreement.
Correct. I think that that's the rationale, Your Honor. And so going back to the issue here, which is kind of who decides kind of the issues that appellants have raised here, I thought going into this argument that their argument, like in their appellate brief, was going to be that all of their issues went to contract formation as opposed to arbitrability. But I heard kind of on appeal, or on oral argument, kind of a concession or an admission that their arguments really do go to this issue of arbitrability. And I want to put a fine point on what I understand their arguments to be, because I think the framing of their argument is very important here as it relates to the issues that you were discussing with the Coinbase versus Susky decision, which I will get to in a second. But I think it's important to understand what I understand them to be arguing in the district court, what they argued in the district court and what they're continue to argue on appeal. Their argument is that there are two separate and unrelated agreements. You've got the deposit agreement, right? And then you've got this promissory note. They were executed at different times. According to them, they involve different subject matters, right? They note in their papers that one does not reference the other, right? That the promissory note doesn't reference the deposit agreement doesn't reference the promissory note, and they argue, and this is in reply brief pages 3 and 4 of their papers, that, and I want to get this right because I think it's important. They argue that the deposit agreements and the promissory notes are two separate and distinct agreements that do not and cannot reasonably be understood to affect one another. So you have two agreements unrelated to one another that don't affect one another. And their argument is simply, as I think, Judge Harris, you pointed out in your back and forth on oral argument, that they believe that their claims relate solely to the promissory note and do not relate and are not governed by and are not controlled by, are not significantly related to use the words of American Recovery, the agreement in the deposit agreement, right, that contains the arbitration provision. So their argument, I think, is a classic arbitrability argument, right? It's does the claims that they brought fall within the scope of the arbitration provision, right? And under American Recovery, we know from both American Recovery and General Electric that that is an arbitrability dispute. From this court's decisions in both American Recovery and General Electric, the courts analyzed those issues. There wasn't a delegation clause in those cases, so the court addressed the issue, but they analyzed these issues as arbitrability issues, and they applied the presumption in favor of arbitrability.
Can I ask you the sort of flip side of the question I asked your friend on the other side? Let's assume the deposit agreement didn't exist, and the only agreement that existed was the promissory note, okay? You agree there would be absolutely no basis to send any questions to an arbitrator then, right?
I agree with that.
Because there's no arbitration clause in the promissory note, right? And to the extent their argument is, you know their argument. Their argument is the promissory note refers to courts, it has a merger clause, it says nothing, literally nothing about arbitration. Second, it refers to courts. Third, it has a merger clause, which you drafted, to say, like, don't pay attention to anything else. This is the whole agreement. I guess let me put it this a different way. They certainly, you agree, I think, could have made a Coinbase argument here, right?
Yes, they could have, but they didn't,
Okay.
right?
And if they had made you also agree the district court did not address any sort of Coinbase argument here.
That is correct. I agree
So
with
you
that.
agree that if they made a Coinbase argument, we would have to vacate and remand?
Yes.
Okay.
I agree with that. But the simple fact is that they did not make
Okay.
a Coinbase argument. And I want to be very clear as to how my understanding of Coinbase works. Coinbase dealt with it obviously dealt with the two contract situation in the context of a delegation clause, right? And the impact of the two contracts on the delegation clause. But, and I think that this is important, and this is why I wanted to frame what I think their argument was, it dealt with a very different type of two contract argument, right? Specifically, the Coinbase decision, and they framed this in their question, and they answered it at the end of their opinion, dealt with the question of whether the later agreement in time supersedes the earlier agreement. In other words, and they determined that that is an issue that must be decided by the court and not the arbitrator, because it relates to an issue of does a valid arbitration agreement exist?
So let me pause it.
Or a delegation clause exists.
Let me
in the
reframe
first
it. I think we're on the same page in terms of that interpretation of Coinbase. So this argument is, look, I agree that at time one, we made an agreement. And I agree that if all we were looking at is the time one agreement, we'd have to arbitrate here. But after that agreement, we made another agreement. And that agreement clawed back some of agreement one. And now I don't have to arbitrate anymore.
Correct.
That you view as, that's a Coinbase argument.
That is a Coinbase argument. And
But it presupposes that agreement one calls for arbitration.
Correct. The argument is my claims would have fell within agreement one, but this later agreement came around and it modified in full, it replaced in full or in part, either rendered null completely or modified
Well,
in
you could,
part.
like, imagine the promissory note said, I know it doesn't say this,
Yes.
but imagine the promissory note said, notwithstanding any prior agreements, any disputes between us shall be resolved in a district court in the Central District of California.
Correct. That would be closer to, yes. And in fact, I do want to point out, you asked whether they could have made this argument. In fact, other PPP recipients in a district court in Northern District of California bringing very similar claims did bring and did raise Susky-related arguments. This is the Happy Puppy case that we referenced in our brief. And there, the district court actually considered the issue because they were operating under the predecessor to what became Coinbase versus Susky, right, the Ninth Circuit's version of it. And so the court addressed that issue on the motion to compel arbitration and actually rejected it and said that the later agreement is not in conflict with the earlier agreement. The venue provision in that agreement is not a mandatory and exclusive provision. that mandates that all claims have to be brought in court. Rather, the provision simply says if you bring claims in court, it has to be decided, or it has to be brought in this particular jurisdiction, and that could be reconciled with the earlier agreement. They also found no other kind of, for instance, in the venue provision or in the integration clause, no other express language of superseding or other
So
language.
can I ask you, like, I realize this is like 5 steps down, and I think you don't think we should get to this question, but let's assume for the sake of argument, we think we can reach a Coinbase argument. Let's assume for the sake of argument that we would do it ourselves instead of remanding to the district court. I realize there's a lot of assumptions built in. But this is something that Coinbase is like shockingly unspecific about, which is how you do a Coinbase analysis. Like, so can I ask you conceptually, let's imagine that they had made a Coinbase argument, and let's imagine that the district court, well, I mean, among other things, if we were going to remand, we should probably tell the district court something about what they're supposed to do. Is the question whether it is, like, I mean, here's an easy example. The agreements are in fatal conflict about whether to arbitrate or not. Agreement 1 says arbitrate, and Agreement 2 literally says don't ever arbitrate. Fine, Coinbase tells me how to do that, I guess. But that strikes me as relatively unlikely to happen in the real world. What strikes me as much more likely to happen in the real world is a situation like this, where Agreement 1 says arbitrate, and Agreement 2 doesn't say arbitrate, and it says some things that seem in tension with the notion you'd arbitrate, but it doesn't say don't. Is the question whether the agreements are fatally inconsistent, like that Agreement 2 is fatally inconsistent with Agreement 1? Like, what is a court supposed to do when it's trying to decide the question that Coinbase said a court is supposed to decide?
I think it's a good question. I think it ultimately turns on state law, so each state could have a different.
Okay, under Maryland
Yeah,
law,
yeah.
what is the court supposed to do?
But I'll get to your, so the fundamental inquiry, kind of in a supersession argument, as I understand it, is the inquiry of whether a clear intent is shown in the language of the agreement and otherwise, that the later in time agreement was intended to replace in full or in part the earlier agreement. So courts look to see whether it involves the same subject matter, for instance, like an earlier term sheet regarding like a phase 1 of a project, and then there comes around a full kind of, you know, agreement that covers all phases 1, 2, and 3 of the project. And there's language in there that's indicating that it's regarding the same subject matter, and there's agreement language in there that indicates that it's intended to replace kind of the agreement that only related to phase 1. So they look to see whether it relates to the same subject matter, and then
But can I
also
take a
look
sec- you said something at the beginning, I just want, but you think the presumption is that Agreement 1 is still in effect? They essentially have to rebut a presumption that Agreement 1 is still in effect?
Yes, I think that they do. I think that they would have the burden of showing that it is not still in effect. And I think that they would have the obligation to show that it relates to the same subject
Well, then
matter
that seems really-
and an intent for the later agreement to replace. And just to get
Yep.
very briefly to your question, I think that conflict analysis is part of it. Whether the language in Contract 2 irreconcilably conflicts with the language in Contract 1, but I think that's only part of the analysis. You have to look for other language. Oftentimes courts look, even where there is tension, they look, if there isn't language that specifically, for instance, refers to the earlier agreement and says this agreement is intended to be supersede or replace, or language to that effect, oftentimes courts won't find a supersession.
So then it becomes really important that the way you conceptualize Coinbase is addressing only supersession questions, because, and let me posit, I agree with you, when Coinbase frames the QP, they use the word supersession, and when they frame the holding at the end of the opinion, they use the word supersession. But then all throughout the opinion, there's analysis that does not seem obviously limited to supersession contexts, and can simply be read to a how do you reconcile two agreements, as opposed to just supersession. And I will confess that I'm struggling with, I mean, Coinbase clearly applies to a supersession argument. I'm not sure how, if at all, Coinbase applies. It's not supersession, it's just that we made two different contracts. I'm not arguing that 2 supersedes 1, I'm just sort of arguing that 2 is the relevant one, not 1.
So I agree that there is some loose language kind of in the middle of the opinion, or maybe it
Like
wasn't loose. But the way I read it is their entire rationale, like I view this, all of their language as being ultimately directed to supersession, because their entire rationale, they made very clear that the reason they found that these supersession arguments are ones for the court to decide and not an arbitrator is because, in their view, they go to the issue of validity of contract, right?
The arbitrator can't decide whether we've agreed to arbitrate.
Correct. And if you have a supersession argument, the argument is that this later agreement changes or modifies in full or in part, renders null the earlier time agreement. It's rational to conclude, as the Supreme Court did, that those types of arguments are ones that go to the court, right? Because they relate to contract formation, which has always been for the court. So I think that the reasoning and their reference to supersession, even though in other places they frame maybe the question a little bit more broadly, it ties back to the nature of the supersession argument and the nature of that being related to contract formation. If you read it more broadly, it would be in tension with the Supreme Court's long line of cases as recently as 2019 in the Henry Schein case that has made clear that arbitrability disputes, questions as to do my claims fall within the scope of the agreement, always, in the face of a clear and unmistakable delegation clause, always must be for the court, or for the arbitrator to decide and not the court, even when they're wholly groundless. So to read Coinbase versus Susky more broadly, to apply to the run-of-the-mill kind of arbitrability disputes of the type that appellants are raising here, I think would essentially require you to read it to overrule kind of Henry Schein and a long line of other cases that have made very clear that that's not the case. And
Wait, can I start? I just want to make sure I'm following. So Judge Hyten said you could have an argument that Contract 2 supersedes Contract 1, or you could have an argument that's more like, look, there's two agreements here, and we just think the second one governs. And your answer is clearly, if it's a superseding argument, that's Coinbase. And if it's the other kind of argument, you are at least coming very close to basically deciding, is this claim that you think is governed by 2, does it actually fall within the scope of the arbitration? Okay.
I think that second argument is
Okay.
an arbitrability
But the
argument.
trick is not the word supersedes, right? It's displace, control over, claw back. All right, so if I'm understanding right, this whole thing then turns on the forfeiture question. And I agree that the plaintiffs don't say supersede in their briefs, but there is one place where they say that the promissory notes have clearly negated the delegation clause from the deposit agreement. Is that close enough?
I think that there is a stray reference in there in one of their pages, but everywhere else they say, as
So if
I
there was
said-
an argument heading that says the promissory note negates the deposit agreement, if that was an argument heading and then there was an argument under that, that would be enough.
Right, and, correct, but they
It's
didn't
not
do
a
that.
magic word test.
Correct, it's not a magic word test, but I think that very clearly they have made clear, and I want to say two things on this. So very clearly, I think, by emphasizing in their reply appellate brief, their position that the later agreement has no effect, can be construed to have no effect on the earlier agreement, that's the exact opposite, no matter what words you use, of a supersession argument. Because a supersession argument, by definition, is that the later in time agreement does have an effect on the earlier agreement. So that concession, I think, makes very clear that they are arguing pure arbitrability, that my claims have nothing to do with the deposit agreement. I think that it's also very important to note to this forfeiture or waiver issue that they have kind of waived this or conceded, I think, on 3 separate occasions that they are not making a supersession or a Coinbase related argument. In the district court, while the motion to compel was being briefed, the Happy Puppy decision that I referenced before came out. We issued a notice of supplemental authority. They responded to that and said, and the Happy Puppy decision referenced and turned on an analysis of Coinbase versus Susky in the Ninth Circuit. And the plaintiffs, in response to our supplemental authority, said, no, that's not that Ninth Circuit precedent that the other case relied on has nothing to do with our arguments here. And they framed their kind of response saying, we're not arguing what was argued there. Instead, we're arguing, and I'm paraphrasing now, essentially that my claims have nothing to do with the deposit agreement. Then as I think Judge Hyden's or Judge Harris, I can't remember which, noted kind of during appellant's oral argument, on appeal, in our appellate brief, we specifically called out the Happy Puppy cert decision. We argued that they had not raised that argument below or on appeal, and therefore had waived it. It was 4 pages of our argument. They did not respond to that at all in their reply brief. They didn't cite Susky at all, the cert petition or otherwise, in their reply brief. They didn't say, here's the elements of a supersession in state law, and here's how we satisfy it. They don't even use the word supersede at all in their reply appellate brief. So they have in our view, conceded our argument that their claims have nothing to do with a supersession argument as addressed in Susky. And then finally, at the same time that they were submitting their reply appellate brief, they were required to identify for this court any, cases currently pending before the Fourth Circuit or in the Supreme Court that raise similar issues. They did not identify Susky. They didn't identify anything else. We actually did note the Susky decision on appeal, but said it doesn't apply to our case because it raises a different issue, the exact argument that we're raising here. So I think 3 times, the baseball rule, 3 strikes, you're out. They denied that they were making a Susky-like argument here, and instead their entire argument is, you've got these 2 contracts, my claims only relate to one and do not significantly relate to the other. That is an arbitrability argument. General Electric, American Recovery from this court make that clear, that it's an arbitrability argument, and Henry Schein and Gibbs and many others from this circuit make clear that where there is an arbitrability argument and there is a delegation clause that expressly delegates that to the arbitrator, that's for the arbitrator to decide, because otherwise, if you, I'm out of time, Your Honor, I think, so I can stop there.
If you want to finish your thought.
I was just going to say, to read, going back to the Susky decision, to read kind of Susky broader to cover these arbitrability arguments would also make no sense because it would negate the very purpose of the delegation clause. The delegation clause is expressly directed to arbitrability type arguments. If the court were to find that you have to address essentially the arbitrability arguments before applying the delegation clause, it would be circular and it would kind of render meaningless the delegation clause. In several courts that we cited to the First Circuit's decision in the New York Life Insurance versus Policy case make that very point, that arbitrability arguments can't be decided before applying the delegation clause because it would render those types of agreements meaningless. So with that, I'll stop.
Judge Berner, do you have more further questions?
No, thank you.
Thanks.
Thank you, Your
Thank you
Honors.
very much.
Judge Haytens, if I may, just real briefly, I think you had previously asked whether we had raised the issue of supersession in any of our lower court briefing. We do, on Joint Appendix 589, say that unlike the cases...
What are you quoting? What is that Joint Appendix 589?
It's the opposition to the motion to compel arbitration, Your Honor. There we distinguish the cases cited by Bank of America and make the point that unlike here, the parties in those cases had not entered into promissory notes and the terms of these superseding agreements were not at issue. I do want to talk about the scope of Coinbase a little bit because Mr. Smallwood has adopted a very narrow view of that. And I don't think it can be read narrowly. And that's based, first of all, on the language of Coinbase itself, but also on a number of cases that have looked at it since its decision and have not limited it to not limited it to issues solely based on supersession. Further, in our reply brief, although we don't specifically talk about the Coinbase case, we do address the issue, quoting the Johnson case, that where 2 contracts are separate, the lack of an arbitration clause means disputes over the agreement are not subject to arbitration. So it's an issue that we had previously raised, not specifically to the Coinbase case, but it is an issue. And again, the distinguishing factor here, and what undermines Bank of America's argument with regards to Coinbase somehow undermining the Henry Schein decision, is that Coinbase is limited to those instances in which there are 2 separate agreements. And Coinbase uses broad language in looking at those agreements. It says that the substance of the parties' dispute is whether there is an agreement to arbitrate. That's been the substance of our argument from the beginning, that there is not an agreement to arbitrate in the deposit agreement that pertains to the claims related to the promissory note. And Coinbase specifically says, because the defendant there argued that their approach in that case would invite chaos, that whereas here, the parties have agreed to two contracts, one sending arbitrability disputes to arbitration, and the other explicitly or implicitly sending arbitrability disputes to the courts, a court must decide which contract governs.
Okay, but there was an important language in there you sort of glossed over, the part where it says, you have to, for doing this analysis, assume that contract one would send this to an arbitrator. You agree with that?
Well, there has
Two
to be a
agreements, one
conflict.
of which sending the
Yes.
question to arbitration. That, the sentence you just read said
Yes.
that first agreement sends it to arbitration.
Yes. And we are arguing that the first agreement has a delegation clause, but that it doesn't apply here. And that's really the Coinbase-based decision, does an agreement exist that sends the disputed issues to arbitration? We think the answer is no.
But you just said you think the answer is yes, that the first agreement would send it to arbitration, and now the question is whether the second agreement.
Yeah, I'm sorry if I misspoke, Your Honor. It's not that it sends it to arbitration, it's that there is, in fact, an agreement between the parties that is subject, that has a delegation clause that would send some claims to arbitration.
But it would send whether these claims go to arbitration under the first agreement, the arbitrator would decide that.
Exactly, yes, Your Honor.
Okay. Can I just, a quick follow-up? You said when you stood up that you think a broader reading of Coinbase is appropriate, both because of what the opinion says, but also you said that there are a bunch of courts applying Coinbase broadly. This is just for my benefit. Do we have those cases in front of us? Are they in your 28J letter?
We don't, Your Honor, and I don't want to overstate it. I wasn't meaning to imply that they have applied Coinbase broadly.
Okay.
Only that they've looked at Coinbase and have not found it to apply narrowly to only supersession arguments.
Okay, can I just say, if there are cases you want us to look at?
Yes.
It would be good if we knew what they were.
It's Baxter versus Miscavige, 2024 Westlaw 359-7120 in the Middle District of Florida, and Williams versus Experian Information Solutions Incorporated, 2024 Westlaw 387-6171, which is from the District of Arizona.
Okay. I think, I am not exactly sure, but it's probably best if you wouldn't mind sending in a 28J letter with those, and then your colleague will also have a chance to respond. Great.
Absolutely, Your Honor.
All right. Thank you very much for your time. We are going to come down and greet counsel and then take a short break, and then we will return for our last case.
Thank you, Your Honors.
This honorable court will take a brief recess.
The standard for treating opioid use disorder requires at least two components. The first is medicines like methadone that can alleviate short-term cravings. But the second, equally or more important, is the provision of therapy, things like cognitive behavioral therapy, that can address the underlying causes of addiction. Our complaint alleges that in September 2020, the defendant's treatment centers stopped providing therapy but continued dispensing drugs. This took the facilities outside of compliance with core conditions of their certification and provision of opioid treatment to government beneficiaries. Nevertheless, they continued to bill the government as if all of the services were provided, and perhaps most shockingly, they prepared false notes indicating that fictional therapy sessions had occurred. Crediting these allegations as true, they state multiple violations of the False Claims Act, which protects the government from fraud on its healthcare programs, among other programs, and ensures that those programs can function with integrity and provide services to the government's beneficiaries.
So there was some language in your brief that suggested that they had obtained certification based on false premises, but just to make clear, your claim now, and I think this is the claim in your complaint, is they were providing these services, and then at some point they stopped providing these. It's not that it's not like a whole bunch of people got together and said, like, let's have a pill mill from the beginning. That's not the claim.
That is correct, Your Honor. However, the certifications do have to be periodically renewed. It's every 3 years. And so in the relevant time period between then and now, a renewal has taken place, and so that
But a renewal, not an initial certification.
That's correct, Your Honor. But the requirements for renewal are no different than the requirements for initial certification. And so that's the basis of the fraudulent inducement claim that we've discussed, the idea that you get to be certified, get to provide these services. You're required to certify your compliance with the requirements that we talk about in the brief, including the provision of clinically adequate therapy services, including keeping a record-keeping system that is adequate to document patient care. And during the relevant time period, they did not have that.
So I think you just addressed a question that I have a whole series of questions, like crediting for the sake of argument that that there are these false therapy notes. One question like, why is someone creating these false therapy notes? The allegation in the complaint is not they make these false therapy notes and then they submit these false therapy notes along with the request for payment, right?
That's correct. The
So
notes,
for your theory, why are they creating these false, like what's the reason that a person would create these false notes in your view? Is it auditing related, like you just alluded to?
that's right, Your Honor. We think the only reason to create a false therapy note is so that if somebody comes knocking to ask, hey, where are the patient records relating to these therapy sessions, you can say, here they are, and you have them ready to go. And those audits do occur in connection with government healthcare programs. States and the federal government can conduct these audits. That is the only reason I can think of why such notes would be created. They serve no other function other
People
than
generally don't go to a whole lot of effort to create false things for no reason.
experiences can vary there, but I think that that's
So
a...
if the false notes were not presented, so why isn't your case like Nathan and Grant, where there was no false notes presented,
Your Honor,
false documents presented?
So, Your Honor, what is presented are the claims for payment, the requests for reimbursement that go to the government programs. And our argument is that those claims are false. In the case of Medicare, we argue that they are false under the implied false certification theory. And that is to say, when Medicare receives a claim using the bundled billing code, so the bundled billing code is a code that you can use if you've provided at least one of the covered services, and that would be medicine. It also includes therapy, dispensing medicine, and other services as well. We say that a core assumption behind allowing them to use the bundled billing code is that they actually have available and are providing the full suite of required services. When, as here, critical services are not being provided, the bundled billing code is implicitly false because it is suggesting we have provided the appropriate services for this patient in this week. It is not
Suggesting under the bundled billing code, they had to have provided every single one of the services in the suite?
No, Your Honor, that's exactly why the bundled billing code exists. It's because, let's say, for example, a patient needs therapy twice a month, but they need medicine every day. You would use the bundled billing code every single week, And it would encompass all of those things, and it would be okay if that's what you were doing, because the idea behind the bundled billing code was to make it easy for providers to bill when there were these variations in treatment from week to week. But what it is not an excuse for is not providing critically important services to patients at any point in time and saying, yep, here's the bundled billing code. That's why it's implicitly false.
Can I just make, there's a lot of claims here, and I have a whole chart and everything, and just so I understand, so you are not, this is the only theory on which there would be falsity for the bundled billing, right? You agree with the district court that you can't show falsity kind of the old-fashioned way, that each bill was itself false.
That's correct. This and fraudulent inducement both
Yes,
relate
got
to
it.
the
But
Medicare
not in the
claims.
same way as over on the fee-for-service side, you can say, look, you billed for group therapy and there was no group therapy.
That's correct, Your
Okay,
Honor.
thank you.
And so, the district court here did believe that the bundled billing code does not imply the provision of these services. We think that's a clear legal error that this court should correct. As I've explained, the point of the bundled billing code, precisely because it doesn't require services to be enumerated, it rests on the fundamental assumption that therapy services are being provided. In fact, when the bundled billing code was created, and we have this cited in our briefs, the government assumed that there would be regular therapy sessions, and it put that in the Federal Register. And when it set the amount that you get for the bundled billing code, there's a drug amount and a non-drug amount. And the non-drug amount necessarily makes assumptions about what kinds of services are being regularly provided.
It's even more, like, right, isn't the non-drug amount more than the drug amount?
It is for all of the ingestible drugs. For the injectables, it's a little different. But yes, for most of the claims in this case, it's more, which tells you what the government is putting emphasis on and really paying for. When you're thinking about, for example, materiality in this case, what are they paying for? The non-drug stuff more than the drugs. And so when you have a service that's not providing the non-drug therapy, that's a major issue for
So
materiality.
can I ask about materiality, what is the best fact in the complaint? And I'm going to preface this by saying an allegation that does not itself contain the word materiality, because that creates like a Twombly-Iqbal problem. Like, you can't prove something's material by alleging it's material. What is the best fact in the complaint showing the false therapy notes would have influenced the government's decision to pay the claims?
So what I believe to be true is the way that I would consider materiality in the context of the false therapy notes specifically is I would say if the government knew that there were falsified therapy notes and no therapy sessions, would it believe that they had complied with the conditions of certification, would it determine that they had complied with the conditions of certification? And I think the answer is a clear no, and we allege that in the complaint. And would it believe that the complaints, that the claims involving the bundled billing codes were accurate? And for the reasons that I just gave you, that the amounts are calibrated.
For a paragraph, where is that articulated in the complaint most cleanly in your view?
Sure. As it relates to the point about certification, I've got paragraph citations I can give you about that. If it's okay, I'll do it when I get back up
Absolutely.
to give you the precise citations. I don't want to misstate
Ask you
them to
another
you.
hypothetical question. If this was a case not where there were false records of therapy being provided, but simply there was no therapy provided and no false notes, same bills, same facts, just no false therapy bills created, would that be a different case? Does this turn on the fact that they falsified records, or does it turn on the fact they didn't provide the therapy?
The latter, Your Honor. I think there would still be a valid claim in the hypothetical you describe. But the reason why I think the false therapy notes are quite important is because they shed a lot of light on what was really going on here. I have a lot of sympathy for healthcare providers who, during the pandemic, found it hard to provide services. You could imagine providers who really tried their best and sometimes weren't able to do it. But sympathy runs out, I think, when you have a pile of fake records. And so I think that what the false therapy notes show you is that this was real fraud. This was not just negligence or failure to do enough. So they go to scienter, which is not an element that's really been disputed in the district court or on appeal. That's why I think it could be relevant. But I do think in your hypothetical, if they're doing it knowingly and they're doing it, with the same scienter as we have here, it's the same claim.
Can I ask you a question about the implied certification theory for the bundled billing under Medicare? So the theory is that the company is impliedly certifying that they've complied with the adequate counseling regulation. So-
And the record-keeping regulation, sure.
Oh, let's start with adequate counseling. And that's material. And I see how the complaint alleges very particularly that they're not providing adequate group counseling, but I'm not sure I see sort of a comparably particularized allegation on the individual therapy side. And there are allegations that these are happening by phone and they're cursory. But what would you point me to as sort of the most kind of concrete and specific allegation that they are failing to comply with the individual counseling end of adequate counseling?
Yeah, so those, the allegations you just described are them. They're on pages 90 and 91 of the joint appendix. And what we do say, and I think crediting these allegations as true, it is sufficient, we say they did two things that were wrong with regard to individual therapy. They stopped providing in-person therapy and shifted to phone-only therapy, even though they did not first attempt to discern whether more involved methods of communication were available for particular beneficiaries. And second, the calls themselves were cursory phone calls where no real therapy occurred, brief check-ins and things of that nature.
But I seem to remember that when you get to those allegations, they all get very caveat, like they frequently didn't involve much, or they generally speaking didn't involve adequate therapy. Like on group therapy, the complaint makes some very strong claims, like we stopped group therapy. And when I look at the allegations about individuals, it's like often, most often, frequently, minimal, not adequate. It starts to get really caveated really fast.
That's true, but I don't think the caveat hurts us at all. Look, we have to be honest. Can we say for sure that no therapist ever had a phone call that really went through the thing? No, we can't say that. But the point is that by and large, they weren't. And that is something our client does know and can allege. And once you have that, I think that gets you essentially to where you need to be in terms of whether we are stating a claim, because the requirements to provide individual therapy require that it be clinically adequate. It's not whatever the provider decides to call individual therapy is going to be good enough.
I know, but, and I know that mens rea, it's not really an issue as this case comes up on appeal, but I do feel like if the thrust of your allegation is, look, this counseling was too cursory and it was not adequate, like you also have to show and allege that, and everybody knew it, and like whether something is adequate or not, it just seems, I have some anxiety around that.
I understand the point, Your Honor, and that probably will be a debate, but standards of care are always debated, right? They're debated in medical malpractice cases, they're debated in False Claims Act cases, experts talk about them and courts figure them out. That's not really a basis, I think, to throw the case out at the pleading stage. That's really more a matter for the proofs. But even if you don't like any of the allegations about individual therapy, we have at least one clear false claim based only on group therapy. The claims that we have about patient 6 that we talk about, this is a patient who was only ever given recommendations for group therapy. You know, they talked to a counselor who said in their treatment plan they would benefit from group therapy. They had false group therapy notes put in their file. They did not receive any group therapy. I think that's a reasonable example of a false claim.
That patient 6 tees up something I wanted to ask you about, which is this conceptual question. Assume for the sake of argument, I know you don't agree with it, but assume for the sake of argument, that I think your allegations about Asheville are sufficient, that I probably think your allegations about other clinics in North Carolina are sufficient, but that I think your allegations about outside of North Carolina, let's just say I think are egregiously insufficient. And so then, let me rephrase. If those are the only allegations you had, I would be like, that is nowhere near close. So is there like do we then dismiss the non-North Carolina claims or affirm the dismissal of the non-court? I've been trying to figure this out, but then I realized that in most contexts, what I'm thinking about would be dealt with through standing or class certification. Like, for example, if I allege someone discriminated against me based on a prohibited ground at my place in North Carolina, and then it's like, I hear other people are being discriminated against in Seattle, I mean, the reason that case would get thrown out is because A, I don't have standing, and B, I can't get class certification under Walmart. But how does that work in the False Claims Act concept conceptually, where the plaintiff alleges sufficient stuff about place X, but then makes broader allegations about place Y?
Yep, I see time's up. I'll try my best to answer it. So the relevant inquiry you're looking at is the Rule 9b inquiry. Right? Are these allegations particular enough? And the way we think Rule 9b works, and the way we think it has to work, is that it's sort of a binary inquiry. That is, have we stated a claim? And if we have, then the full scope of the fraud is really a question to be dealt with after discovery. What you want with Rule 9b is you want the defendants to have notice of what we're accusing them of. They have that. They have not said otherwise. And you want this to be the type of case that isn't based on mere speculation where all the evidence needs to be acquired in discovery. We have that too. We have the false therapy notes that we have here. We have personal observations. We have other evidence that's gathered pre-discovery, which is sufficient to cross the Rule 9b threshold. Now, I don't think courts parse that threshold on a claim-by-claim, facility-by-facility, government by government program basis. I think they do it holistically.
Are you familiar with our decision in Taylor versus Boyko, where we seem to have affirmed that kind of thing?
Yeah, so I think that this case is quite different from that one. And I guess the way that I put it is,
But we did affirm, like in that case, we were like, the claims involving the relator are fine, the other claims dismissal affirmed because there's basically insufficient allegations about them.
yes. So I think here we do have more allegations, but I'm taking for purposes of the question,
I appreciate
your idea that we don't. I think the right way to look at them, to look at this is as a threshold question, and once the threshold is crossed, it's crossed for the whole claim. And the reason I think that's correct, there's a couple. The first is when you have these False Claims Act cases where there may be hundreds or thousands of claims, there's almost going to be nobody anywhere who can ever plead a complaint that touches them. And so what you would effectively be doing is creating a rule of law that says, you know, there's no enforcement action against the worst claims, the worst frauds. I think that's an important consideration in this context. Second, I think the question really goes to, are the allegations addressing some sort of root cause that could be triggering the more widespread behavior, right? If our allegations were really only about the behavior of particular clinicians or supervisors at one facility, then I think there would be a better argument to say, you've got to limit the case somewhat. Here, however, we have allegations that say it's happening at this facility. Through conversations with others, we know it's happening at least throughout North Carolina. And then the false therapy notes are being reviewed at the corporate level, and edits are being made to them, suggesting that it's going broader still. I think that's enough to cross the Rule 9b threshold. Now, when this case goes further, when we're doing summary judgment or trial, we're going to have to prove this up. There is no doubt about that. And if the evidence is not there to sustain the idea that there are claims, false claims of a similar kind elsewhere, then those claims will not be actionable. But I think that for purposes of the Rule 9b pleading threshold, the right way to look at it is there enough in this complaint to satisfy those two purposes of Rule 9b for the case? And if there is, we talk about the rest later.
Before we let you sit down, I'm sorry. Can I just ask a quick question about, I can't remember, is it count 6, the reverse false claim?
Yes, Your Honor.
Count, yeah, okay. So tell me if I'm wrong, but it seems as though the question here, whether we have an obligation, is whether the obligation here, which I think is the stipulated penalties for violating the CIA, whether those are established by the contract itself or whether they sort of come into being when the government takes some discretionary action. Okay, so explain to me why the obligations, the stipulated penalties here are sort of created by contract and don't require the government to take some action.
Sure. The way the contract is phrased, so at a broad level, corporate integrity agreements are basically designed to create these obligations. They're designed to say you're taking on these obligations to do these compliance things. When you fail to do so, you are stipulating the penalties, effectively liquidated damages for these things that you will pay us to streamline the enforcement action, right? To make it so that the government doesn't have to do nearly as much discretionary stuff as it would have to do to, for example, bring a False Claims Act case. And so here, what the contract says is it says there are specific stipulated penalties for each of these violations, the reporting violations, the training violations that we talk about. It also indicates when those penalties start to accrue. They start to accrue from the day of the violation itself in many
It says
cases.
the date the obligation becomes due. I don't know what that means.
Yeah,
That
so I
makes
think it would be
sound like
the,
when someone sues for it, and now you have an obligation to pay the money.
I think it's the obligation to report or to provide the training is the obligation that I believe is being referenced there. You know, if you think that, whether that's ambiguous or not, the other side has not made the argument that that's ambiguous. So I don't think that argument is really before you. We haven't briefed it for that reason. You know, all they have said is that because some discretionary action is necessary, you know, you can't have anything there, and they haven't grappled with the contractual language at all. And so,
you think the fair reading of the stipulated penalty begins to accrue on the day after the date the obligation became due. They're not just saying sort of how many days you're going to, they're not saying that on the first day we sue you for every following day. You think it's,
the day you were supposed to do the thing.
okay.
And so we think the penalties basically accrue automatically from the violations, and as a result, the obligation is mature enough. The tricky thing about the reverse FCA provision is that there's a tension in the language, right? It talks about an established duty and then says whether or not fixed. And so you have to figure out, how can something be established but not fixed? I think Congress spelled that out in the legislative history when it said contingent contractual obligations are included. And so to the extent that you think there's an ambiguity there, and I think that's the ambiguity every court has wrestled with, it's resolved in this case by what Congress actually said.
So does that mean that any contract, what if it didn't have these stipulated damages provisions? Like would that still count as just a not fixed?
The way I would put it is that if the contract obligates you to pay, and the only thing the counterparty to the contract has to do is say, pay me, and you're required to do it, that's enough. The decision to have them say, pay me, can't be a block, because then you could never have one of these claims based on a contract, right? You could imagine that if, for example, we had a contract where I said, you know, if I file a brief less than 10,000 words, you know, I get $100 or something like that. Yeah, and then in that case, you know, and I lie about the word count or I exclude the word count certificate, you know, trying to get out of or let's say I had to pay you if I did more than 10,000 words, you know, and I don't include the word count certificate, right? Then that would be a clear example of where I have an obligation, right? I owe you the $100, but you still have to come collect probably. Otherwise, you've waived your right to do so. So I think that's how this contract works and how these generally ought to work.
Okay. Judge Berner, do you have? Okay.
No, thank you.
Everyone else is
Thank you.
prepared to let you sit down, so.
Good morning. My name is Jennifer Weaver, and I am counsel for the respondents. May it please the court. Despite the impressive length of Ms. Wheeler's amended complaint and the very well-composed recasting of its allegations, what I want to focus the court on is the central and most important requirement for any False Claims Act complaint, and that is specific facts that show with plausibility and particularity that an actual false claim was submitted to the government for payment. And that's something that no matter what theory the relator is espousing here, and the theories have shifted, this fundamental rule applies to all four of the direct false claims counts, counts 1, 2, 4, and 5.
Well, can I ask you on the fee-for-service claims, which I think is 4 or 5, the non-Medicare claims, the allegation, right, is billed the government for services, group therapy, that did not exist. And then you covered yourselves with these fake notes. On these claims, you're not disputing falsity or materiality, are you?
Yes, I am.
Okay, tell me why those would not be false claims.
So to plead falsity, again, whether it's fraudulent inducement or false certification.
No, I'm sorry, I meant, did I say it wrong? I meant not the ones that are coming in under the implied certification or fraudulent inducement ones, but the ones that just say you billed these non-Medicare providers, you said, please pay me for group therapy, you coded it, I provided group therapy, and in fact, there was no group therapy. You were billing for non-existent services. That would be false, right?
That would be false if
Okay.
it were adequately pled under this court's precedents in both, I mean, throughout, from the
Well, to
Nathan
plead
case.
that, they say you billed for group therapy that you did not provide. You think that's not in the complaint?
It's not in the complaint, and let me explain why.
Okay.
So presentment, and that a false claim is
But
presented to the
presentment
government.
is different. I'm just asking, before we get to presentment,
Okay.
assume this thing was presented to the government, and it said, please pay me for group therapy services, and you did not provide group therapy services. That would be, I think, false?
Assuming, again, that it was adequately pled, that there were facts, and this again in the grant test,
I
because,
don't see why, I mean, the district court certainly assumed that these would be false. Is this really where you want to plant your flag? I was just trying to get you to say, yeah, obviously false, but they have a problem on presentment. That's what the district court said.
yeah, it would be false again, but it had to be based on facts that can either show a false claim was submitted or that it was necessarily submitted.
Okay, so you
That
just want
leaves-
to talk about presentment.
Yeah.
I really am just trying
Okay.
to check through my chart. Assume hypothetical person X, me.
Handed the government a piece of
Right,
paper.
I,
that said-
I go to the government and say, here are my receipts for my trip to Richmond. In fact, I stayed home. That's false, right?
Yes, if you can assume that, which this court's precedent advises against
Sure,
assuming.
But that's presentment. And then the second is, if I say, here's my receipt for my trip to Richmond, and the government, and then, please pay me $800 for my hotel. And I'm asking for $800, that's pretty clearly material, right? Because I'm asking to be reimbursed for a specific amount of money that I was not in fact expending. That's obviously material, right?
Yes,
So now the only question is whether I ever handed that.
Okay.
yes. And that's why I think that that's the key that ties these all together.
Well, that's fine. I just want to
Is-
make sure we're
yeah.
all on the same part of the argument.
And that's why,
Okay.
again, there's been a well-made argument, but it's untethered from the facts that are pled in the complaint, and we need specific facts. And then when we kind of look in, and I want to focus the court's attention on the facts that are actually pled, not as described. And so the only facts about any claim that was submitted to the government, that plausibly was submitted to the government, is for patient 6. That's the only federal health care program patient identified in the complaint. And so what are those facts that are pled in the complaint? One, that patient 6 is a Medicare and Medicaid dual eligible. And as the relator admits in paragraph 372 of the amended complaint, Medicare is the primary payer for such dual eligibles, meaning the claim for patient 6 would be submitted to Medicare. And then relator admits at paragraph 244 of the amended complaint that these are, as we've discussed, are submitted on a weekly bundle. And those services that are included in the bundle, and this is at 42 CFR 410.67B. The services are the drug itself, methadone or buprenorphine, dispensing or administration, substance use counseling, individual or group therapy, and again, counseling and therapy are two separate services, and then individual therapy is different than group therapy, toxicology testing, intake activities, and periodic assessments. So that's the services that are included, covered by the bundle. To bill Medicare for patient 6, only one of those services needs to be provided any given week. Relator alleges in the amended complaint that patient 6 received methadone, that's one service. Relator alleges in paragraph 622 through 627 that a counselor met with patient 6 on July 13th of 2021 to update his treatment plan, and that during that meeting, patient 6 told the counselor he was struggling to stay abstinent and he had a hard time processing his past traumas. So that's substance use counseling. That's another service. Relator alleges that his patient 6 treatment plan notes 2 previous drug screens were positive.
Can I, just because we are so short on
Okay.
time, so am I understanding right that your point about patient 6 is that, what is your point about patient 6?
My point about patient 6, which are the only facts to support that a claim was submitted to the government or necessarily submitted show that
There was
patient
no
6.
falsity.
There was no false claim at all.
Because that's a Medicare claim. But when we're over on the fee-for-service claims, counts 4 and 5, I think your colleague actually concedes they don't have a specific claim being presented. They are instead trying to come in under the sort of alternative way we have said you can meet that element, which is by alleging a pattern that would necessarily lead to the submission of false claims. And so my question for you is, I mean, there's a lot in here about the pattern, detail about how the billing works, and you have the allegation that these bills are routinely paid, and you have the false notes. And I'm really stuck on that, because why would you be making all these false notes about non-existent, I don't mean you personally, why would one make false notes about non-existent group therapy sessions if you weren't planning on billing for them? What would be the purpose of those notes?
Well, I mean, I can't tell you what the purpose would be because it would just be assumptions. We know that
Well,
for.
but if we can rule out every other purpose, it's kind of not an assumption anymore. So I guess I am asking you to entertain kind of the hypothetical question. If these notes are not being made to cover up what will be false submissions, what purpose could a healthcare provider have for producing intentionally, as alleged, false notes of group therapy sessions that never happened?
Well, I mean, just speculate on that. It could be for patients that are not government patients. It's some other requirement
So
for
they're trying to defraud different
a commercial
payers, but
health
not the
plan or
government.
something that has nothing to do with the government patient. Because we can't assume, again, I think it's
Yeah,
telling,
so that's your answer, and
To defraud someone else.
to defraud somebody, not the government.
or that there was some, I mean,
That might be a
engage
perfectly
in.
good answer, I just want.
Yeah, it's hard because and that's the whole point of this, is that I'm forced to think about, what could have
There
happened.
is case law that relies on things like this and says, because we cannot think of any purpose for these specifically alleged cover-up activities, we can think of no purpose other than to support a false claim, we are going to say that this pattern necessarily did lead to the submission of false claims. So the case law kind of forces us to answer this question. And I know you want to keep fighting the premise, but I'm telling you, the precedent requires me to ask that question, so an answer would be good.
Yeah, and could it be that it was for, assuming it happens, of course, we're going to contest that that is true.
Yes, of course.
But for some, reason regarding the individual's job requirements that they were trying to maintain, that they were doing certain things that they were required to keep their employment, even if it had nothing to do with a federal health care program patient or any claim that was submitted to the government for payment. I mean, that's possible. Could it be for non-governmental patients? It's just very
But
hard.
the complaint alleges that 2/3 of, I think it does. The complaint does it not allege that 2/3 of your client's revenue comes from the government?
I believe that it does.
So like, it'd be different if it was like, the argument it's for other purposes is like only 2% of our money comes from the government. There's no reason to believe this was for the government. But in a world where 2/3 of the revenue comes from the government, it seems like if you're going to do a massive fraud that only covers 1/3 of your customers, or your payers.
Well, again, we're stepping away from the premise that, and this amended complaint conflates a lot of different concepts.
Yeah, but
in
there's
terms
no,
of-
whatever else you can say about what this amended complaint does and does not adequately allege, it pretty clearly adequately alleges a systematic process of creating false therapy notes. It definitely alleges that at quite a bit of level of detail.
It talks a lot about group therapy notes. I think it's important to note that Medicare does not require group therapy. It's not a requirement for North Carolina
But
Medicaid,
I guess, at least
TRICARE.
my question was about the non-Medicare claims. So if we, rather than switching over to the Medicare claims, where I do understand your argument,
Yeah.
and for what it's worth, I am really wrestling with the presentment question on the non-Medicare claims, but we may have already fully plowed that ground.
Could I ask you a different sort of practical big picture question?
Sure.
Which is like, if we dismiss this complaint, how does a relator who doesn't work in billing or management ever satisfy the pleading requirements, in your view?
I think that they would do it by describing with some more detail about, well, for example, Ms. Wheeler also is not a therapist or a counselor. So she not only has no involvement in billing, she has no involvement in providing counseling or therapy services. If you had a relator who was a counselor, who said that I was instructed to falsify notes to say that I provided these counseling
You say that lets
services.
you maybe bring a complaint about the things that you personally were involved in, but you would say that's not enough to say anybody else could.
I mean, there has to be some factual basis to back it up other than rumor, innuendo, the idea that false claims must have been submitted or should have been submitted without sufficient facts to show that they necessarily were. And so, you know, on the implied certification, I mean, I do think because of the facts, and to go back to patient 6, there's detailed facts about all of the services he did receive, the drugs, the counseling, the toxicology testing, the assessments, the updates to his treatment plan. That's all in there. And so if those are the facts, and then to take from that and extrapolate from that on an implied certification theory that false claims must have been submitted all around the country because of underlying non-compliance with different unspecified regulations, I think it,
Specified the regulation, isn't it the adequate counseling regulation?
yeah, adequate
Okay.
substance use counseling. And again,
Well, that's
the
specified.
actual facts pled in the amended complaint describe adequate substance use counseling that patient 6 received. There's no allegation that patient 6 did not receive adequate substance use counseling. There's no allegation about a single patient anywhere in the country, not in the Asheville Clinic, not anywhere, who did not receive adequate substance use counseling. And so from that,
Well, I think I understood their argument to be, your colleague's argument. There were some patients for whom group therapy, and group therapy specifically, was thought to be the most effective or adequate form of counseling. And we specifically allege that there was no group therapy going on. So at least for some patients, they were not getting adequate therapy.
well, I think that's a question under, I think, the court's precedent in Taylor v. Boyko, Nicholson versus Medcom, North Carolina, and Nathan and Grant, that's not sufficient.
It's not specific.
It's not sufficiently, I mean, if you look and just compare the facts pled that were found to not meet 9B, especially in Taylor, are much more specific than the facts here. So to say that, I mean, patient 6, the allegations in the complaint was that his treatment plan did not require group therapy, that some other unspecified patient that is not identified has a treatment plan that is never described that did require group therapy but didn't get group therapy, that I think is too far of a leap and an assumption, because again, if it leaves open the possibility that no false claim was submitted, I mean, that's what the Grant test is. You've got to shut that door. If you leave open that possibility that that a false claim wasn't submitted because their treatment plan didn't require group therapy in the first place, and no one billed for group therapy because if it's Medicare, it's not even possible to do that. I think it's important just to back up and think about, again, what these services are and what the requirements actually are for medication-assisted treatment of opioid addiction. Many of these patients are patients who are in treatment for very long periods of time. You might be on methadone or buprenorphine for 5, 10 years to maintain your sobriety. And that's why CMS did not impose specific requirements that everybody needs all of these things. You need adequate substance use counseling as clinically necessary. Someone who's been in treatment for 10 years probably isn't getting group therapy and a bunch of counseling on a frequent basis compared to a person who is just coming in and starting treatment. And so that's why there's not that specific requirement. We can't, because we only have one patient to work from. We only have one, and we know he got adequate substance use counseling in addition to multiple other services. And so, when we think about the purposes of 9B, and it's, part of it is to prevent cases from going forward when there's not substantial pre-discovery evidence to support them, because it's a big deal to accuse people of fraud. It's not a small thing. And so here, it's telling that relator at the lower court never asked to amend to add additional facts, to say, hey, look, I've got a Medicaid patient in Nashville. I've got another patient that definitely their treatment plan said they needed it, they didn't get it. There was never a request to amend to add those facts. And I think that's because if they had them, they would have asked to amend to add them, and they don't.
Can I ask you a quick question about
Sure.
count 6, the reverse
Yes.
false claim? Is it your understanding that there's not an obligation for purposes of the FCA if the duty to pay out the money is contingent on the government's discretionary decision to enforce the contract? Is that your
Yeah.
position?
That is my position, and I think I agree with the district court's ruling and the reasoning in Sturgeon versus Pharmaerica, where they relied. Those CIAs are virtually identical to ours here. And so what they say is that failure to comply with certain obligations may lead to the imposition of monetary penalties. The exact same provision is in the Pharmaerica CIA, the Acadia CIA. And so it's not as relator alleged in their briefs that all that the OIG had to do was to decide to collect the penalties. No, they had to decide to impose them in the first place. And they're not required to impose stipulated penalties for any violation, no matter what. It's a discretionary decision, and they could choose to impose them or not.
Okay, so actually then I think maybe I misunderstood your answer to my question. It's not your position then that government discretion to actually sue to recover on a contract is enough to mean that there is no obligation. There needs to be this additional government discretion.
Right, I'm sorry,
Okay.
I misspoke.
Or maybe I got it wrong, yeah.
Sorry, no, I think that that's the key part of the holding, is that the exercise of government discretion is what makes it not an obligation.
But not just, here is my concern. If we say that the fact that nobody ever owes money in a contract case until someone sues them for it. So if we say that the government's discretion in deciding to sue on a contract is enough to mean that there's no obligation, then no contract can ever give rise to an FCA obligation, which seems inconsistent with the statutory text, which clearly contemplates contracts as one thing that can give rise to an obligation. So I'm asking you to address that concern, which your colleague raised.
I think what I would say is that, False Claims Act cases can definitely be predicated upon contracts, but this court, as well as the Supreme Court, has made clear that the False Claims Act is not a vehicle for any kind of breach of contract case or
Right.
anything.
So what would a
And
contract
so-
have to say to give rise to an obligation that would support a reverse False Claims Act claim?
It would have to be definite enough that the only thing left to do, that because if you're going to accuse someone of a fraud, then a reverse false claim, it'd have to be definite enough that the imposition of the penalty, the requirement to pay is automatic, like in a liquidated damages clause.
Well, there is a liquidated damages clause, and if I understand it to be saying your stipulated penalty of $2,500 a day begins to accrue the day after the day on which you do not perform an obligation under this agreement, then is that good enough?
I don't think so, because I think it's still, that provision, I think, is contingent, first upon the OIG deciding to impose stipulated penalties in the first place, which
How could the OIG decide to impose the penalty when the OIG isn't aware of the fraud?
I think what they've alleged is that a failure to report. And so for this claim to have any legs, what they would have to allege are, again, facts.
Yeah, I think
that-
they're alleging that you certified you were in compliance with the CIA when you weren't, because you weren't making the necessary reports. So that certification was false, and so now the question, just assume like all of that is alleged. So now the question is this obligation in this contract an obligation for purposes of the FCA? And I'm trying to figure out an answer about how much government discretion is too much. And if it's a liquidated damages clause, and it says specifically, it will begin to accrue on the day when you commit the breach, is that not enough?
I think it accrues on the day you commit the breach in the event but the OIG still needs to decide to impose it in the first place.
So it is basically, you are saying if the government retains discretion as to whether or not it wants to sue on its contractual rights, then there's no
Not necessarily
obligation.
sue, because what the contract, the CIA,
Well, what else does impose the liquidated damages mean but sue and get them? Like, you think there's an intervening step? Or
yeah,
first-
when you're under a CIA, the OIG monitor can make certain decisions, and that's what it spells out here, that they can decide to impose those or not, based on, whatever the underlying factual circumstances
Well,
are.
there's a paragraph 8 that says, and this is different from 1 through 7, that says the stipulated penalty will only begin to accrue 10 days after OIG sends a notice saying like, yeah, we're serious about this. But the other 7 don't say that. So I read the other 7 to mean something different than 8 because they use different language. 8 seems to be what you're describing. The OIG decides that, yeah, I'm going to enforce these liquidated damages provisions. But 1 through 7 doesn't have that language.
Yeah, I think, but it does still have the language that the court relied on, also in the Farmerica case, which again, no matter what one of those 1 through 8 we're looking at, it still gives the OIG discretion to impose or to not impose penalties. It's not.
Where should I look for that language?
I can get you the site, let me,
I'm sorry, I don't mean to put you on the spot. I will read it. I'll find it. Okay.
okay. It's cited in our brief, and I can find the exact page
I'll
on the
get it from the
joint.
brief. Thank
but,
you. Okay.
I mean, I think it's also important here, and a reverse false claims case counts also need to be pled with particularity. That Ms. Wheeler doesn't plead, I mean, she does not plead any facts that she was involved in the process of submitting reports to the OIG under the CIA. She pleads no facts about what was or was not reported, so she doesn't know any kind of representations that were made to the OIG or anything that was back. And, again, it's this idea, what she says is that in her amended complaint is that, and it's a way that this reverse false claims theory kind of gets bootstrapped or to turn what, in my view, are inadequately supported allegations of direct false claims to then rely upon that theory to revive them. If she doesn't have sufficient facts to show with plausibility or particularity that even for a single claim, patient 6, and that's, again, we go to her amended complaint, that's what she said. She said, I told them about patient 6, that he told me he didn't get group therapy. I looked in his charts, and it said he did get group therapy. So if we take that as true, again, why are we assuming that that would have to be reported to the OIG? They didn't bill for group therapy, his treatment plan didn't require it, and he received adequate substance use counseling.
Okay, I want to give you, I took you way over time, so I want to give you time to wrap up, but Judge Berner, do you have questions?
All right. Thank you.
Thank you very much. Before you even start, can I ask a question that goes directly to what we were just talking about? That's why. So your colleague says basically like, look, if you haven't sufficiently alleged counts 1, 2, and 4, and 5, like there's nothing to talk about by the time we get to 6, because the failure to report that underlies your claim for the false certification of compliance with the CIA is sort of dependent on the other allegations. Is that right?
I don't think so. There is some overlap in the underlying facts, but there are also things that are involved in the reverse False Claims Act case that don't involve the rest. So for example, there's a training requirement, and one of our allegations is they didn't provide that training. They didn't provide it to my client, and she says they didn't provide it to anyone. And that's completely independent of whether they violated the corporate integrity agreement in other ways. For example, by failing to report known or suspected likely violations of the law. For that one, I think our allegations say that my client reported to her superiors, as did the director of the North Wilkesboro facility report to her superiors, that these fraudulent therapy notes were being created, at which point they were told to stay in their lane and no action was taken. It was also confirmed that similar actions were occurring throughout North Carolina. We think those are reportable events under the CIA, even if they don't rise to the level of false claims independently. And so I think that the reverse false claims allegations are in some ways broader than the other allegations, such that that would not be true. And I think you just heard the other side basically admit that it's going to be almost impossible to bring a claim based on a contract, because in the context of the CIA, what OIG has to do to get the money is send a demand letter. That's a contractual enforcement mechanism, so they don't file a separate lawsuit. But that's the analog to filing a suit under another breached contract, right? It's just a streamlined procedure between these parties. No different functionally. You know, the same level of discretionary involvement is there. And so their approach would get rid of effectively all claims under contracts for reverse false claims, which can't be right because contracts are called out in the statute as a potential basis for reverse false claims. More broadly, I think the real focus, I think, of the last 20 minutes was on Rule 9b. And, you know, is there enough to show presentment of false claims? And I think that what you're seeing is an attempt to create an effectively impossible pleading standard. That is, you know, you have to have allegations that are about this specific program, this specific geography, this specific conduct. You can always ask for more particulars. But the question under Rule 9b is not, could this complaint have been more particular? It is, does this complaint satisfy the purposes of Rule 9b? Providing the defendants with notice of the allegations against them. And again, even now, going through oral argument, the defendants have never suggested otherwise, other than that it does. And the second purpose is weeding out the clearly spurious cases, the ones that are just pure fishing expeditions, which this case is not. We have substantial pre-discovery evidence of pretty substantial wrongdoing. That is, the creation of false group therapy notes to paper over the fact that group therapy was not being provided to patients who needed it. These group therapy notes only exist for patients whose treatment plans say they should get group therapy, because again, otherwise there would be no reason to create them. And so we have facts that necessarily lead to the implication that false claims were presented. The other side's best answer to this is to say, well, maybe we were just trying to defraud somebody else. I don't think that should be an excuse, especially when, as here, they get 2/3 of their revenue from the government, and we have identified a Medicare Medicaid patient for whom the false group therapy notes were created. It's certainly not a plausible inference from the complaint that they were only doing this vis-a-vis people who were not government beneficiaries. We say they were doing it across the board. We provide a specific example of a government beneficiary for whom they did it, and that's really enough under Rule 9b. I can understand looking at the complaint and asking, like, why can't there be more here? You know, why can't we also have a specific fee-for-service claim? Why can't we have a claim outside of North Carolina? I get it. The problem is that many times relators who are witnessing fraud, and our relator had a decent vantage point into this. She worked at the company for about 7 years, starting in 2014. She saw exactly how the conduct sharply changed in the fall of 2020 and observed it for almost a year before being terminated. She had a pretty good vantage point into what was going on here, but she's not on the submitting claim side or the reporting side. What she knows is that when she raised these issues internally, she was told, stay in your lane, even when she points out egregious misconduct, like the creation of false group therapy notes, that I think is just beyond the pale of what any honest treatment provider could reasonably do. I want to circle back, Judge Heitens, I promised you cites. So we were talking about materiality for the fraud and the inducement type of claim. And so as we explained in the brief, what you're going to look at here is, was this essential to the bargain? Are these express conditions of payment? And what has the government done in similar actions? Now, some of our best stuff here is not actually in the complaint. It's the Rhode Island case that we talk about in the briefs, where the government has gone after an indistinguishable provider. And what they have said is that these very same requirements that we're suing under are clearly material because they go to the essence of the bargain, they are express conditions, and they're the types of conditions that are so close to being conditions of payment that the fact that they're labeled conditions of participation is irrelevant.
And the JA sites that you want to draw my attention to are what?
Yeah, so those ones will be pages 106 to 109 and 118 and 119. But those don't talk about the Rhode Island case. They don't talk about, the facts that the government said there, but we think all of that is stuff that you can consider because the materiality analysis is a legal analysis. The facts that are alleged in the complaint on the pages that I told you about are, you can't be certified if you don't comply with these things, and that is effectively materiality plus. It is saying, if you don't do these things, you're not qualified to dispense methadone to government beneficiaries, and there's a very good reason for that. It's because methadone is potentially highly addictive, and if you're just handing it out, that becomes indistinguishable from mere drug dealing if you're not also providing these other critical services.
Judge Berner, do you have questions?
No, thank you.
All right, then we'll allow everybody to sit down. We will come down and greet counsel, and then I'll ask that court be adjourned for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.